Hi everyone, thank you for joining us today. I'm Michael from Justuno. I help run the partner marketing here. Today I'm joined by Jody from Red Clover Advisors. Jody, do you want to give us a little bit about yourself?
Yes. Hi, I'm Jody Daniels, founder, CEO, and privacy consultant at Red Clover Advisors. We are a data privacy consultancy. So we help really with the operational piece of complying with different privacy laws. And it's important to know that we are not attorneys. So I am officially not providing legal advice here in our discussion today.
Great. Thank you, Jody. So let's hop right into the first question, which is what is CCPA and what challenges do they pose for merchants, if any?
So, CCPA is the California Consumer Privacy Act, and it was passed in June 2018 and became effective and enforced in 2020. Now, what's interesting about this law is it's the first comprehensive state privacy law that we have in the United States. And it also has some floors, it kind of has some minimum criteria, and companies only have to adhere to one of them to have to be in scope. So, one is that a company earns $25 million of global revenue. So, you could earn $1 in California and the rest globally. And technically speaking, your California customer put you in scope. The second could be that you are collecting, processing, buying, selling, sharing, doing something with 50,000 records from either consumers, households, or devices. Anyone can think about maybe 50,000 website visitors because the digital data kind of counts as personal data. So if you had 50,000 unique visitors that maybe are from California, that might put you in scope. So the 50,000 is unique to California. And the third option could be that a company earns more than 50% of its revenue from selling data. That's really aimed at the data brokers, probably not most of the merchants that we're talking about today. So as a reminder, companies only have to be in one of those buckets. Now, what's also really interesting is this is kind of known as CCPA 1.0. But in November 2020 at the election, voters passed what we kind of affectionately call CCPA 2.0, officially named CPRA, the Consumer Privacy Rights and Enforcement Act. And that becomes effective January 2023. Companies need to know about that law so they begin preparing for it. And you have to have kind of the 1.0 version under your belt before you move to the 2.0. And what's important is it does raise that threshold from 50,000 to 100,000. So for some companies, you might be technically under that threshold, but when you move forward, if you're underneath that 100,000 in time. But
Right.
that kind of begs the question, if you're too small, do you still need to comply with the law? And I would say that yes, you do, because the end customer has no idea about the nuances of the law, and they're just going to be familiar with what they're seeing at other companies, which are updated privacy notices. There's a series of requirements that need to be in a privacy notice. Individual rights, the California law offers a variety of rights, meaning Jody could ask you to delete my information I gave you, or access the information,
Mhm.
or ask you to opt out of the sale of my information. And in the new CPRA, there's some additional criteria. I won't go too deep into that because right now we're really focused on CCPA. But companies need to be able to honor those individual rights. So merchants have to focus and understand the data that they have so that they can make an accurate privacy notice and meet the specific criteria that has to be in there. You've probably seen cookie banners.
Mhm.
Cookie banners are actually not required, but you are starting to see a movement towards a cookie banner because you need to have notice at the time of collection. So a lot of people like the cookie banner. You can still just have a privacy notice, but you also have to allow the user to opt out of those cookies, because in the ad tech space, it's kind of a gray zone, but it's really generally accepted right now that the use of cookies like Facebook and Google and pick your favorite advertising cookie is considered a sale of data. And I use the quote sale
Mhm.
because sale, most people think like a dollar for dollar. but in the definition under CCPA, it can be for other valuable consideration. So it doesn't have to be a dollar for dollar exchange. So net, another big piece that merchants have to deal with is if you're using any of those targeted ads or any of those types of pixels, you might have sold the data under this law. And another requirement is you have to have a do not sell my personal information link on the homepage. So go to a website and you might see in the bottom or the top or in a cookie banner, also manage my cookie settings and do not sell my personal information.
Gotcha.
So those are kind of the big highlight chunks at the like 30,000 foot view of CCPA.
Gotcha. That's awesome. Thank you for running us through that. One question I had there is, so technically it's a Californian law. And so if a brand, whether in the US or anywhere else, but they interact with any Californian customers, which ultimately with a big enough brand, they're going to ultimately, most likely at some point. What are they, if say they're based in Europe or if they're based really outside of the US or Europe, how will they be impacted if they infringe on those privacy regulations?
That's a great question. The law applies to the customer, where the customer is. It doesn't matter where the company is.
Okay.
Very similar to GDPR, which applies to where the person is. The person needs to be in the EU. It doesn't matter where the company is. Now, the difference between GDPR and CCPA, well, there's a lot of differences. One of the big ones is that floor. GDPR applies whether you have $1 and one customer. CCPA kind of puts those floors in place to really try and help ease the burden on small companies. But as I said before, the end user has no idea if you make $20 million, $5 million, $100 million, or how many people you're collecting data on, right? They just kind of see you as the merchant and they're buying XYZ. So from a privacy point of view, that's a technicality, and we really have to look at the people and the interaction and the trust and the expectations. But the other companies that are outside of California would be responsible to follow the law just like any other law.
That kind of leads me to my second question here, which is how should merchants approach auditing their own website and any marketing they send out? Because it applies to emails, SMS, texts you send out to your customers or visitors. And so how can they ensure that they're in line with CCPA, and what are some top item strategies?
Yeah. So the very first thing that they need to do is understand the data that they're collecting and the different vendors or software that they're using. So literally go on the site and think about the order process. What kinds of information is being collected in that order process and who is managing it? Is it all in Shopify? Do you have Shopify plugins? Are you using not Shopify, but other tools? Does Shopify link to other things, or do your vendors link to others? So you really want to go through the process as if you're a customer for your order process. What if I have questions? What if I want to contact you? What about customer support? How do I engage? Can I call on the phone? Can I send something in? What are all the different ways that people can engage with the company? And essentially, it's always the same questions. It's what data are you collecting? Is it name, email, dress size, favorite color, ages of kids, hair color, whatever it is? All those different data elements, and then where they're being stored. Is it in Shopify, HubSpot, Zoho, my favorite purple company, whatever tools it is? Is it a Google Drive, a Dropbox? And then who's accessing it? Are they all employees? Are they contractors? Are they agencies that you've hired? Are they consultants? Are they third parties? Because the company, the merchant's responsible for the whole chain. So for whomever I'm sending data to, I need to make sure that that company is going to also adhere to CCPA. And one of the things we didn't dive into is the protection of data, the security side. We need to make sure that we have appropriate security measures in place on our side and our vendors. Well, we can't know our vendors that we have to be responsible for if we don't take the inventory to know. And the same would be true for marketing. Go through all the different marketing channels and marketing activity that you're doing and ask the same questions. What am I collecting in email? Where am I getting the emails from? Am I buying emails? Am I sharing emails? Am I augmenting? Where are they all stored? What is the purpose I'm using for them? So We utilize Microsoft Excel, Google Sheets, all the way to privacy management software when we're working with clients to do this. So just kind of think about those processes, make a list of the process, make a list of all the data elements and all the places it's stored. And then the last part is of the places it's stored and the companies you're working with or the people doing it, you need to make sure you have the appropriate agreements in place, whether that's an actual agreement or you clicked the terms, but you have to vet who all those vendors are, again, to make sure that they are complying from a security standpoint, that they're using it not for other purposes. So if you signed up and you vendor A, you can use it for me, like to store my data. Well, then they can't use it for themselves. And are they? Because there are companies that do that. And the final piece is making sure that if you're using a third party or vendor or service provider, and they all actually under the law have very special definitions.
Mm-hmm.
Right now I'm using them interchangeably. But if Jody comes along and wants to have my data deleted, you're likely using one of those softwares. So you need to know, well, how would I do that?
Mm.
Is it self-serve me, the company? Can I build it in? Do I have to contact them? How do I do that? And so those are the pieces that you need to understand.
Gotcha. And that makes me think of under, I believe it's the GDPR regulations, for a data privacy officer, a DPO, and which some companies have. And so I wanted to hear your insight into, should all companies, brands look into having a data privacy officer on hand to, make sure this whole process, should Jody request to have their information deleted, have all that nailed down. And if there was a certain, say, company size or anything like that that might warrant having that sort of role in the company.
A data protection officer under GDPR is a very specific role that kind of has regular privacy items to it, but also some very specific kind of regulatory requirements. I definitely recommend any company of any size that has some type of personal information have someone responsible for privacy, but it doesn't need to be full-time and it doesn't need to be internal. So we serve as fractional privacy officers for a lot of companies, and it could be someone who's just part of their role is going to be the privacy piece, and then they work with external folks to make sure that they know what they're doing. But someone should have knowledge and working with the appropriate people for privacy. It's now too big with more states. Today we're talking about California. Also passed that we're not talking about today is Virginia. So in January 2023, that CCPA 2.0 that I talked about is going to be joined with Virginia. And there's more states that have bills on the docket that might get passed. It's a growing field. Customers have additional expectations. Security risks are increasing. So you certainly need to have someone managing the security pieces, but the security and the privacy pieces are different because following the email marketing rules, for example, for what you can and can't do under GDPR in the e-privacy directive. So how you can email people in the EU and how you can email people in Canada and how you can email people in the United States are all different.
Right.
And what the disclosure requirements are going to be also are different but similar. That's very unique from protecting my data in my database. So security and privacy are different, but they're connected.
Awesome.
Yeah, I hope that answers your question.
No, absolutely. Yeah, you corrected me. Yeah, I thought it was data privacy officer, not data protection. So that's fantastic.
And so many companies have a data privacy officer. And actually, when you said DPO, I went to the GDPR version of a DPO, which is the protection part. But I do think everyone should have a privacy officer, which is sort of your more general privacy operations person in the company. And again, it doesn't need to be full-time. Just someone whose responsibility is to pay attention. And then for those smaller companies, they likely just need to work with some outside folks to make sure they have the information that they need.
What is the number one thing a merchant could do if, let's just imagine, they haven't done anything, they have like the bare bones privacy policy, and then let's just say that's it. They don't know a whole lot, and they want to learn more, and they want to become fully compliant to both protect themselves and as a whole, improve the end user experience, which is what this is all about, right? Protecting users from companies using their data without them knowing, without them wanting to, and spam emails, things like that. So yeah, what's the number one thing that they should keep in mind and that they should take away from this?
Privacy is, first off, it's here to stay, and it's all about transparency and choice. And then obviously from a security perspective, protection. If I have a privacy notice and I haven't gone through the data audit that we just talked about, I likely don't have an accurate privacy notice because I have to know the data that I have and how I'm using it and what I'm collecting and what I'm using it for to be able to have an accurate privacy notice. It's not just a legal document. Yes, it is a legal document, but it's not just a legal document to put on a website and check a box. It's meant to be a tool to explain what is happening with the company and the user. Now, you're starting to see companies go beyond just the long, boring legal document, and they're making privacy pages with principles. And here's why we care about your privacy, and here's what your choices are. And they're building preference centers. So when you send that email marketing message and you don't want me to just opt out, you're going to let me have choices. So the extreme choices under these laws are deletion and access. But the whole concept is it's my data, the individual. Let me have the choices. So imagine a preference center. I sent that email campaign and let me downgrade. But let me kind of see all the privacy pieces all together. So the kind of the nut and bolts of like the first thing you should do is understand that privacy is about trust. It's not just a law. We have laws because companies mess this up. And they messed up because they weren't honest. And then they didn't give people choices. So now we have a law to tell me what you're doing and then give me choices about it. We're very reactive around here.
Right.
So it's all about the trust game and trust the relationship, right? We're selling stuff to humans. The human on the other side, just tell me what it is that you're doing. Think about it first, determine should I be doing that, and then give me my choices. And to do any of that, you have to go to our middle part of our conversation, which is know your data.
So it's all about the end user experience, and it's a kind of perspective shift from it shouldn't be an us, my brand versus them, my customers. It should be a kind of a we thing. They're trusting me by telling me about themselves, and you need to honor that trust. And like I've seen like those privacy pages with like it's almost like a code of sort of privacy, data privacy ethics that they list out, which is really cool to see. And I think building any additional trust you can with your customers, especially nowadays with so many other things happening, that's super important, and so that's really great to hear. And my last note here is, so yeah, clearly privacy is here to stay, and it's not going to go anywhere. And so I'd like to hear, I guess, your thoughts on the overall landscape and where you think we're headed. You mentioned other states in the U.S. Writing up their own bills. Do you see this process just accelerating further and further and further to like every state having their own bill, or becoming a federal legislative, bill, or what do you think there?
Well, there has been an introduction of a federal bill almost every year for the last 10, 15 years, and there's one out there right now.
Mm-hmm.
A federal bill many are lobbying for and would like to see. It's complicated for a long list of reasons. We have multiple other existing privacy laws. Are they all exempted? And then who wins? Is the federal law the floor and the states can go above it? Is the state below the federal? So there's all these questions, which is partially why we have no federal privacy law. So I personally think, unless it's kind of political darts, you never know what will happen. Someone might just never know. We're not going to play the political dart game.
Sure.
But at a state level, we have more than a dozen bills out there now. And many states, Washington state is back for the third time. New York has 4 to 6 bills just in its own state. And you will see a rapid progression of other states adopting privacy laws, which is going to be an interesting business challenge to have to navigate. which if you build a strong privacy program, and it doesn't have to be fancy, but understanding your data and having some process in place when you go and change your new vendor, or you create a new landing page, or you want to go do a new marketing campaign, and understanding the nuance is, are you collecting any new data? Are you using new tools or new vendors or tracking people in a different way? That triggers a privacy question. If you have all of those types of things in place, then when there's a new state law that's going to come along, it will be easier to be able to adopt to that. For a company who's done nothing, there's some legwork to get done.
Hmm.
Once you get that foundation, if you do it right, you'll be able to kind of layer on these other states. There will certainly be some effort involved because they're all a little bit different,
Right.
but it won't be starting from scratch in that capacity.
Having that framework in place from the get-go, especially now, because as things ramp up, which they, yeah, most likely will, and whether it's small or big changes, having that core framework of data privacy in place now, that way, as new bills get introduced, you can updating and adding to is a whole lot easier than building it from the ground up when you suddenly have to legally, which you still do right now, but when bigger fines, bigger penalties come into play, there's not that rush to get it all done, and which is just kind of the wrong attitude to have here, right?
Right. We really don't want anyone just kind of rushing, and it's not just a checklist and here's another law, let me get through everything. Yes, it's a checklist. Yes, it's another law, but the whole idea is to to build a sense of understanding in a company and responsibility. This is the type of data I'm collecting, why I'm using it, who I'm sharing it with. And again, that notice and transparency elements, and then choice. And also to make a company think about, do I need this data? Am I just collecting it just because? What am I doing with it? Are there any risks to the end user? So it might seem innocuous of, well, I'm just a merchant, I'm trying to sell, I want lots of
Mhm.
information so I can create a better experience. Well, depending on what you sell, depending on the kind of questions you're asking and the kind of content you have, some of that might be kind of sensitive to some people. you know
Right.
um, think about the size of clothing. If it's clothing, well, a larger person might feel like, well, now you might be able to guess my weight, and could you share that with
Mm.
somebody? If you're in children, well, now you might know, I have children and the ages of my children based on what I'm buying. So while
Right.
it might just seem simple, because so many companies have shared and collated and done a variety of things, the element of trust for an end user has been lowered, and consumers are cautious of working with companies and sharing that data. It's a company's job to sell the amazing product that they have. Come buy my product. This is why it's fabulous. I'm going to send you 15,000 emails and 2,000 texts. Here's why you have to have it. And here's some
Right.
discounts to go with it. But I also want to be able to sell them on, I'm a valid company, right? You can trust me with your credit card. Why do we have seals on websites?
That's fantastic. This is all I've learned a ton here today. I'd like to wrap up with that. So thank you, Jody, for joining us from Red Clover Advisors. Uh, Thank you, everyone, for tuning in today to watch this with us. I hope you learned something. And please check out Red Clover Advisors if you want to learn anything at all, privacy, data related. They kick out great content, and I would love to send some people there. So thank you, Jody.
Thank you.